All right, good morning, everyone. Ms. Linker, go ahead and take the roll.
Commissioner Cardenas?
Here.
Commissioner Hatch?
Here.
Commissioner Hayward?
Here.
Commissioner Wilson?
Here.
Chair Matich?
Here. All right, we'll begin with public comment for items not on the agenda. Do we have any public comment in person for items not on the agenda? Seeing none, go ahead and proceed to approval of the commission meeting minutes from January 2020. Do commissioners have any edits or a motion?
I move approval.
Do you have a second?
Second.
Any public comment on the minutes? Seeing none?
Commissioner Cardenas?
Yes.
Commissioner Hatch?
Aye.
Commissioner Hayward?
Yes.
Commissioner Wilson?
Aye.
Chair Matich?
Aye.
The motion passes.
Move then to the enforcement consent calendar, items 3 through 12. At the outset, I wanted to state that for item 9, in an abundance of caution, because it involves a client of my former law firm, I'm going to recuse myself. Do other commissioners have any items they wish to pull from consent?
I likewise wish to recuse myself on item 9. I'd known the person mentioned in the accusation for many years and worked closely with their organization for decades. So although it's technically not a conflict, I prefer to, as you say, out of an abundance of caution, recuse myself.
Right. All right, then let's proceed with, do we have a motion then on items 3 through 8 and 10, 11, and 12 on the consent calendar?
I move those items.
Second.
Is there any public comment on the consent calendar? Hearing none. Ms. Linker?
Commissioner Cardenas?
Yes.
Commissioner Hatch?
Aye.
Commissioner Hayward?
Yes.
Commissioner Wilson?
Aye.
Chair Matich?
Aye.
The motion passes.
All right. I'm going to go ahead and turn it over to Commissioner Hayward.
Fix that one outside.
All right then, on item 9, is there any commissioner comment, public comment? Seeing none? Sasha, please call the roll.
Can I get a motion?
Is this to approve item?
Yes.
To approve item 9 as presented by staff? Is that,
Well, yeah, it's on the consent calendar. Yeah.
we don't need a motion for, even, we still need a motion, don't we?
Oh, you're right, okay. Do I hear a motion then?
I move that item. Second.
Sorry.
Commissioner Cardenas?
Yes.
Commissioner Hayward?
Yes.
Commissioner Wilson?
Aye.
The motion passes.
I don't know what I was thinking. Can someone go get our other commissioners who were probably just, hopefully just standing out there? Yes, they are. Excellent.
Thank you. We'll then proceed to items 13 and 14. These are notice of intent to present default decision and order at the March commission meeting. Is there any discussion by commissioners on item 13 or 14?
I would like to say something about item 13. As I think many people know, one of the respondents in item 13 is no longer of this mortal coil. Phil Wyman unfortunately died last November. Galena, how do we handle a default or, in fact, any other kind of enforcement matter when a respondent has passed away?
Thank you. Galeno as Chief of Enforcement. So if it's a personal violation like an SCI or personal use or something, then it passes with the person. And if it's a committee violation and the violation's here where the treasurer's responsibility, we proceed without naming the candidate.
Okay, so I am wondering, I don't know how much you can say at this point on this, if maybe part of the default had to do with illness or incapacity of the candidate, and I'm wondering if you can anticipate whether or not having that unfortunate thing be over with, could we maybe anticipate a better response from the committee and the treasurer?
I would hope that the treasurer would respond, but the treasurer hasn't been ill as far as we have known and has been non-responsive.
Okay. I guess I'm going to take this opportunity then with the bully pulpit that YouTube gives me to reach out to people and say, you know, if you are part of the Bakersfield Republican community, could you please let Mr. O'Hearn know that this is an important matter and that it doesn't get better if you ignore it? Whether or not he feels like the Phil Wyman Committee is still a client of his, it is important for him to show up with our enforcement people and come to some agreement as to a stipulated penalty, and because it doesn't get better if you just ignore it. Thank you. I'm done.
Any further commissioner comments on items 13 or 14?
Yeah, I have a question, Mr. Chair. I think I know the answer to this question, but for the benefit of the public, Ms. West, could you explain how a committee is contacted? Are they called? Do they send emails with read receipts? What's the actual process?
Sure. In this case, specifically, it was a franchise tax board audit. So they worked with the franchise tax board for the auditors. They had findings, and then the franchise tax board tells them they refer it over to us for contemplation of prosecution. And then we reach out to them via email, letter, and phone call. And when you receive the default packet next month, each case will actually have a bullet list. That was something that the commission decided to do, I think, about 2 years ago, to give a bullet list of all contacts that this committee has received to try to get compliance. And so they not only do email, phone, and letters, but we generally also try to contact if there's, for instance, a statement of economic interest is missing and the person is still a sitting board member. We will contact the board and ask them if they could contact them and ask them to please comply or contact us. And so we try to do a bunch of different avenues for defaults especially, and then also for when we have to take civil injunction where we make someone file. We definitely go down every road. The joke a couple years ago was, we'll call your mother, because we would contact anyone if we have bad contact information for you. Sometimes that leads to searches that get you old phone numbers that turn out to be your parents. But yeah, we definitely try as much as we can to get people to participate in the process.
And how do you go about getting their mother's phone numbers?
That's classified.
Thank you.
A question, roughly, well, what year was the activity that was subject to this?
This was an Attorney General campaign in 2014.
So these occurred in 2014, yeah.
Any other commissioner comments on 13 or 14? Is there any public comment on items 13 or 14? Seeing none. Thank you, Ms. West. We'll proceed to item 15, This is pre-notice discussion of proposed adoption of Regulation 18310.1. These are public participation at commission meeting guidelines. Sort of tee this up, the commission last year, over 2 meetings, talked about and gave direction to staff for some guidelines that we wanted to make sure were clear on public participation in our commission meetings. Staff has now put pen to paper for us and are presenting these to us for our review and for information.
Good morning, Chair and Commissioners. Kevin Cornwall, Legal Division, presenting for pre-notice discussion the proposed adoption of Regulation 18310.1, which would codify the public participation policies, as you mentioned, that were adopted in September and October of last year with minor revisions generally made for the sake of improving organization, clarity, and efficiency. The regulation is divided into 3 major sections: time, organization, and order, and audio, video, and text-based comments by the public, which is similar to the organization of the policies adopted last fall. The proposed rules are generally aimed at facilitating efficient commission meetings and avoiding or appropriately addressing disruptions to commission meetings. Staff recommends the adoption of the proposed regulation and will incorporate any comments or direction by the commission prior to submission to OAL. Staff also welcomes public comment regarding the proposed regulation. I think the memo covers more in depth some of the details of the proposed regulation, but if there are any questions, I'd be happy to answer them.
Thank you. Do we have commissioner comment on the rules? I had one item that I would raise for the commission's consideration. I think staff has crafted these consistent with the direction we had previously given. As I was reviewing these, one thing struck me, and that is if we have folks coming to provide public comment to us on matters on our agenda, and those folks are registered lobbyists and are being paid to present to us, would the commission be open to considering adding a provision to our guidelines that required disclosure of that fact at the outset, so that we're clearly informed as we're doing this who is a registered lobbyist and who's here in that capacity?
Would that also apply to attorneys that are representing a client?
My understanding,
Because we don't usually get lobbyists, we get attorneys.
my proposal is limited to lobbyists because, as an attorney, my understanding of our ethical requirements is that we can't disclose clients' identification without prior consent. There are very strict bar rules with respect to that.
I understand that, but they could disclose that they have a client, correct? Without naming them?
Presumably they could.
They're there on behalf of a client, as opposed to, I'm here just because I'm concerned personally about this thing before us.
And we have, as a matter of course, requested that type of information in the past.
Yeah. I would like to, if it's possible legally, for us to be able to ask that they disclose that they are representing a client.
If they're an attorney.
If they're an attorney.
All right. Do other commissioners have thoughts on that?
I tend to concur with Commissioner Hatch. That's sort of the customary thing we do already. If we need to put it in the regs so that everybody understands it's still our approach, then I'm fine with that. But it is kind of how we do things already, so.
Right, and part of I want to make sure that we have those rules clearly stated so that the public knows that when they're appearing to testify. So, Commissioner Wilson, thoughts?
No.
All right. Then why don't we go ahead and put it to a vote then? The motion, I would make the motion that staff come back to the commission at a future meeting with an additional provision that requires members of the public who are testifying on behalf of a client, if they are a lawyer, to identify that they are appearing on behalf of a client. If they are a lobbyist and are being paid to come comment to us in that capacity, that they disclose that they are a registered paid lobbyist and who their client is when they provide public comment.
Okay.
Second.
Is there any public comment on the motion? Seeing none. Any additional commissioner comments? Ms. Tucker?
Commissioner Cardenas?
Yes.
Commissioner Hatch?
Aye.
Commissioner Hayward,
Yes.
Commissioner Wilson,
Aye.
Chair Matich.
Aye.
The motion passes.
All right, thank you. Moving to item 16. This is pre-notice discussion of proposed amendments to Regulation 18531, return of excess contributions. Mr. Bainbridge and Staff Counsel Green. Good morning.
Good morning, Chair and Commissioners. Caitlin Green, Commission Counsel, Legal Division. In response to CPAA's comments at the December 2019 hearing, staff requests approval to notice the regulatory changes in Regulation 18531 to allow for a time period in which an excessive contribution may be returned after a deposit has been made. Currently, the regulation only allows for the return of excessive contributions prior to deposit or negotiation within 14 days of receipt, leaving no opportunity to return an excessive contribution that was deposited automatically via a third-party vendor or aggregate contributions that were not immediately noticeable as excessive. Thus, staff recommends allowing a committee to return a contribution or a portion thereof that exceeds the applicable limits to the contributor within 14 days of receiving the contribution without violating the limit set forth in sections 85301, 85302, and 85303. Additionally, staff recommends placing limitations on the opportunity to return excessive contributions as to avoid confusion and complications with compliance. These suggested limitations have been added in subdivision A of the regulation draft, which include the committee not having actual knowledge that the contribution exceeds the limit at the time of receipt, as well as the committee not making use of the contribution prior to returning it. Staff also presents for the Commission an additional limitation in subdivision F, which expressly states that the contribution returned in whole or in part must be reported as a contribution in its entirety if it is deposited. Also, the amount returned to the contributor must be reported as an expenditure. Lastly, staff presents minor non-substantive changes throughout the regulation. If there are any questions or comments, I'm happy to take them.
So just to be clear, you have to, if you missed it, but you correct it within that time frame, you still have to show it was a contribution and then an expenditure for the return. Is that what you said?
That is correct. A contribution would be reported on Schedule A, and then the return would be reported on Schedule E.
Okay, thank you.
So I have two questions. First, sticking with new subdivision F. So my understanding is that's a new provision that staff is recommending. What's the thinking there? Why would we do that?
So the current language of this regulation considers it not a contribution. So once it's returned, then it's not reported, but it's not allowed to be deposited. So right now, if it's deposited, we would like transparency and seeing the in and the out of the excessive contribution.
And then my second question is the staff memo, which I think was very detailed and well-written, and so I appreciate that. You point to several other jurisdictions, including the federal rule, and it seems like there's a pretty wide range of the number of days in which an excess contribution can be returned. And so what was staff's rationale for sticking with 14 days as opposed to, for example, following the federal rule of 60 days?
It was just for consistency. The current standard was to return an excessive contribution without depositing it within 14 days. So we just left that deadline in there, but did provide these in case you did want to expand that or lessen it.
Do other commissioners have comments, thoughts?
I do. Ms. Green?
Yes.
I'm sorry, Ms. Green. The memo, very well written, agreed, quite well done. The memo suggests that this is being occasioned, at least in part, because at a recent meeting, CPAA suggested that there are inadvertent errors that are causing a technical, the technical noncompliance. And the memo suggests that the CPAA attributes it, at least in part, to these recurring deposits that are being made by donors. So then I take it that am I inferring correctly that what some donors then are doing is they are just making like monthly credit contributions through some automatic facility?
Yes, that's correct. There's third-party vendors that allow you to make payments and then have an auto debit, say, every few weeks, every month or so. And the committee doesn't have the opportunity to review those contributions and have the ability to return them as of right now with the current language.
So it's like being a monthly subscriber to, that's very clever. Do we have a sense on our own or through CPAA or otherwise, to what extent this automatic recurring phenomenon constitutes the universe of these inadvertent overages? I mean, is it like 10% of the problem? Is it 90% of the problem? I mean, there's a suggested cause and effect here, but I don't know what other contributory factors there might be.
I'm not exactly sure what the percentage is, and I could look into that for you if you would like me to. But I think the old regulation assumes that people are contributing with paper checks, and that just, I would think, rarely happens currently with electronic transfers, PayPal, credit cards, things like that, things of those nature.
And I would just add, that's part of the consideration we made in drafting this regulation is we want to address the situation where money gets deposited automatically and gets returned quickly in light of the way money is transferred nowadays compared to 1974. But we also didn't want to create a way to get around the rules, which is why we thought having a short period for return would help prevent that, and then also the restrictions on you can't intentionally receive a contribution over the limit.
So this is a pre-notice, so there's going to be a public hearing, public comment,
Yes,
right?
yes.
So CPA and others will have, everyone's on notice. And I'm calling it an overage. Deposits or contributions made which end up being above the limitation. So an overage, repaying an overage amount is reported as an expenditure then, right? Okay. A little over a year ago, we took the measure with the understanding that we might revisit it as the technology and the phenomenon evolves and as our understanding of the phenomenon might evolve. And I'm referring to Bitcoin contributions. And so our position is that they are, one may not make a Bitcoin political contribution within our purview. If someone receives an overage in the form of Bitcoin, that would be reported as an expenditure? The tendering back of the Bitcoin overage amount would be reported as an expenditure?
So under this regulation, any overage received to the committee, the portion returned, yes, would be reported as an expenditure.
But I'll just add, because Caitlin wasn't around for the Bitcoin.
How do you return? I'm hung up on it.
I think if it's a contribution that's in the form of a Bitcoin, it's prohibited contribution to begin with. So I don't know that we would even apply this regulation.
So then what does a person do if they've received it?
Can I interject? You'd have to have a Bitcoin wallet as the campaign committee to take it to begin with. And so if Bitcoin contributions are prohibited, nobody has a wallet, no one can get the Bitcoin.
Well, you might have a wallet for other purposes.
A Bitcoin wallet for other purposes?
Why wouldn't an LLC or some other organization have a Bitcoin wallet for other purposes?
But I'm talking about the recipient. The recipient political committee doesn't have a way to take Bitcoin unless you're thinking in a completely different vein than I am.
Maybe.
So the question wouldn't come up.
Well, let me pose a hypothetical and ask how you would analyze this. So suppose you had a committee that inadvertently turned on the functionality to accept Bitcoins, and somebody deposited a Bitcoin to that committee, and the committee immediately upon discovering that returned the contribution. Is that a violation of the act? And then secondly, how would they deal with the return of the Bitcoin? Would that become an expenditure similar to the rules we have here? Or, as Mr. Bainbridge suggested, are we talking about apples and oranges here, two different things entirely?
I certainly hadn't thought about this scenario in advance. I think if someone had contacted us for advice and said, I received a Bitcoin into my wallet, I realize those are not permissible, what do? I would say, return it, and we'll provide you this written advice as to what you should be doing. Whether it's technically a violation of the law, I don't know. I don't think this regulation would apply in that circumstance. I think that's a unique circumstance that we would handle just by, let's fix what's happened that's wrong and document it would be the way I would approach it.
Well, let me undercut my own question. To whom would you return it anyways, come to think of it?
Exactly.
Commissioner Hayward, do you know how Bitcoin works well enough to answer that question?
Did I miss the answer?
Someone has attached their identity to that contribution. Now, if that's fraudulent, that's not the campaign committee's fault. It would either be to return it to that person, or it would escape to the state if you thought it was fraudulent, which is what happens, I think, with other sorts of, somebody gives you money and it's bad money, and ultimately the state gets it if you don't want to give it back to the donor.
Okay. I stand down. For now. When might this come back to us?
It'll most likely be up for adoption in April.
April. See if I'm busy.
Commissioner Hatch.
I would like to know whether or not this regulation makes any distinction between the electronic payments automatically received and a check, a paper check.
So that is provided for in subdivision A. It does just say a contribution, whether that is a paper check or a electronic transfer. However, there is the limitation that if there is actual knowledge, then it cannot be deposited and then just the excess returned. So if you do in fact receive a check and you know that it is above the limit, then it cannot be deposited with the excess just being returned.
Right, but this new rule would apply to both paper checks and fund transfers from credit card transactions?
Yes, it would.
That's a little troubling in my head. I know that, like, for instance, after the debates last night, two candidates bragged publicly that they'd received more than $2.5 million in less than a 24-hour period as a result of their, debate performance. And I think one of them said it was like 700,000 contributions. So I can get it that the electronic thing, makes sense. But for receiving paper checks, usually are not like $2.70. They're maybe $1,000 or $2,000. I don't think that they should be treated the same. I think, you have a pile of checks and you're going to deposit them. That's the moment when you should be deciding whether or not it's appropriate to deposit them. I'm not sure what the solution is, but I think we should have some distinction between the two. And maybe the checks should be just treated like they are now and not subject to this oops provision.
Yeah, and I understand your point, and I think that's partially addressed by saying if they have actual knowledge that it's over the limit at the time received, then this rule isn't going to apply because you get to see exactly on the check the name of the contributor and the amount. So I think in large part that will be addressed because if you get a check that's clearly over the contribution limit, you're not going to be able to deposit that and then refund it later, because you should know by looking at the
You should
check
know not to
that it's
deposit
over
it.
the
And I
limit.
didn't want to create like a loophole where they could just, deposit them and say, oops, and then, use this rule to undo it or partially undo it.
Yeah, and I think the other scenario where this, in addition to the electronic payments, where this will be helpful is the issue of aggregation. So when someone receives a contribution from an individual and then also receives a contribution from their business, they may not immediately realize that John Smith also owns Smith Construction. In the moment, they may deposit the check and then realize after the fact
see
that
that.
those contributions should be aggregated.
Now, there's one other issue I just wanted to clarify. This doesn't apply to an over the limit for a contribution. In other words, a single contribution is in excess of the limit allowed, as opposed to an aggregate accumulation.
Yes, it would apply to a contribution that is received in total. If it is over the limit, then this would apply.
Okay, just to make it real clear, so I've never contributed to this candidate, but suddenly I give them a $10,000 check, besides what that triggers for me in additional reporting, and the committee deposits that? Because it's clearly above the limits on what they can receive?
Yes, this regulation would apply in that situation.
I don't like that.
But the interpretation of it is that we intend is that that person would, the committee would have actual knowledge that that contribution was over the limit, because on its face, the check is over the limit.
On its face.
Mr. Chair, and that assumes that the committee didn't claim that it inadvertently didn't realize it was over the limit, or, if they assumed an error that, oh, wait a minute, this check is not over the limit, when in fact it was.
Yeah, I think it's hard to argue that you assumed it was
Well-
not over the limit when it's clearly on its face over the limit.
Well, yeah. If someone has common sense like you, then you're right.
Maybe you could consider with the revising the language that for this new treatment, that you use the word aggregate contributions so that it doesn't, so it's clear that it doesn't apply to a single over the limit contribution. Just a thought. Thank you, Mr. Chair.
So, Ms. Green, I just want to make sure now that I'm completely clear, so maybe we can just take a step back. Today, set this proposed change aside. If I'm a committee and I receive an over-the-limit check, tell me how that works, in lay terms.
So if you receive a check that is over the limit, under the current regulation, that check must be returned within 14 days and it cannot be deposited.
Okay. Do the changes that you're proposing to 18531 change that scenario at all?
It could, with the scenario that Dave brought up, where you have an individual contributor and then you have someone's business, you don't realize that it's the same person and they deposit the checks, and then what they found out it was over the limit, they have to return the excess.
Okay, so if we're talking about physical checks, the only change that we're making is accounting for aggregation, where it may not be apparent to the committee on its face at the time they receive the check that the individual has contributed previously and that accepting the full amount of that check would be over the limit. Is that correct?
That's correct.
Today, again, just follow, without these changes, if somebody receives Act Blue contributions automatically into their account, and some of those contributions are over the limit, what is the result for the committee?
Right now, under the current language of the regulation, that money cannot be returned and they are in violation of the act.
Okay. And under the proposed changes, the proposed changes seek to address that problem. Is that correct?
That's correct.
Okay, and just one more time, how would that work under the new reg?
So under the new regulation, the auto debit would be deposited into the committee's account they realize that there's an overage, they would have 14 days to return the excess amount.
All right. What happens if they don't receive the breakdown from ActBlue within 14 days?
Then the regulation wouldn't apply.
And so they would have accepted unlawful contribution and be
They
in violation of the act?
Yeah, they wouldn't have had, I guess, in that situation, the opportunity to take advantage of this exception.
All right. When you guys looked at this, though, my understanding is that when we looked at this, the functionality for those different vendors do provide for notification to the committees of that kind of a breakdown well in advance of 14 days. Is that accurate?
Yeah, that's my understanding is I think they have some discretion on when they receive these reports, and I think they can be fairly frequent.
Okay. So the intent of the reg then, just to distill this down, is one, to address physical checks where there might be an aggregation issue, because previously we hadn't accounted for that. And secondly, to, in a sense, modernize the regs to account for a new form of technology where we're receiving electronic transfers.
That's correct.
Okay. Thank you.
Mr. Chair, I kind of one technical question. A couple of questions I had, Ms. Green just answered, but what happens in the situation where there's automatic contribution to the committee? It's in excess of the allowed amount. What options does the committee have in terms of how it returns the money?
I would think that that money could be returned electronically or in the form of a check.
Okay.
As long as that money is returned to the contributor within 14 days.
And that's 14 days, regardless of whether the committee looked at their bank account and knew that there was a contribution in violation of the amount.
That's correct.
Okay.
I had a couple of follow-up questions, if I could.
Ratch?
ActBlue specifically, depending upon the candidate, I'd like to make it weekly or like to make it monthly is automatically checked or not checked, depending upon I'd say the ethics of the of the candidate. And so it's pretty easy to inadvertently start a monthly or a weekly contribution. My understanding, and I'm not an expert on this, is that ActBlue transfers this in batches. So it's not like they give you 7 million contributions for small change, one at a time, transferring it as they receive it. It's, they give them a batch of money, and then they give them an electronic report of who this represents. Because this is getting more and more popular, and the volume is continually increasing, and the size of these reports as well, I'm thinking that with respect to the small contribution through the third party by credit cards, should have a longer, what do you call it? Right now we're 14 days. I would, myself, I'd think, closer to a month, because it's a huge volume now. And I just think that that's something you should consider. And I kind of thought I got two different answers on this. A single contributions over the contribution limit. In response to the chair's inquiry, it seemed to not match what I was told in my previous question. So if you're not sure, come back to us with, does the new provisions, does that apply to a single contribution, not the mistake of two different checks? One check for me personally over the limit for, say, a state Senate seat, over the Senate's contribution limit. Would that be subject to this new language? If so, I would desire to see it clarified so that it does not, that it would be treated as just over the limit and you can't deposit it.
Our intent in drafting it is that in that circumstance, one check clearly over the limit, the committee would be deemed to have actual knowledge that it's over the limit, and therefore they couldn't apply this regulation, which is essentially an exception.
Okay, thank you. Thank you.
sorry, I know one of my fellow commissioners asked you this, but so this is coming back in April or March?
April.
In April. Have we received any input from stakeholders on this pre-noticed version?
No, we have not. And I did personally reach out to some individuals seeking input, and I have not received any input at all to date.
Right.
They have a reporting deadline today, so.
I heard about that. All right. Thank you. Is there any public comment on this item? Seeing none. Thank you very much. I think you guys, I think you've done great work on this. And I think CPAA, to their credit, raised an important issue for us to consider. And I think when we get through this, we'll be better off for taking a look at this. So thank you very much.
Thank you.
I actually want to take some items out of order, hold off on limited liability, because I think that's going to be a little bit longer discussion that also involves our legislation update and also our law and policy report. And so instead, I'd like to move to item 21 and knock that one out. And that's Commissioner Manual and Code of Conduct update. That's Mr. Bainbridge, Mr. Fesser, and Mr. Cornwall.
All right, I'll get us started here. This is coming back. These were, just to remind everybody, these were policies that the commission approved at the December meeting and asked us to type them up and bring them back for your comment. The intent with these is to eventually incorporate these into a comprehensive code of conduct for the commissioners. This is the former chapters 3 and 4 of the commission manual that we will consolidate into a single document. We will make much clearer and provide all of the rules that apply to commissioner conduct. It will then come back to the commission sometime later this year as a policy for the commission to adopt. We've been working with Commissioner Cardenas on this, so we'll continue to do that. So that's our plan. You will see these incorporated in a more comprehensive document at some point down the line. Just to clarify one thing that may not make sense because it's out of context, because it's not in the comprehensive code of conduct at this point, which is item number 1 regarding ex parte communications. The last sentence mentions that this provision does not apply to ex parte communications concerning pending enforcement cases, subject to Government Code Section 11430.10. This is not to say that ex parte communications are permissible involving enforcement actions. It's just to say there's another set of laws that apply to those. And I think that'll be more clear in the comprehensive code of conduct, because there'll be another section that will probably include a cross-reference to that is specific to ex parte communications in an enforcement matter. So beyond that, if there's any specific questions for John and Kevin here, I'll throw it to the commission.
All right. Thank you, and appreciate your staff's work on this. These certainly look like they reflect what we approved back in December. But do we have other commissioner comments?
Yeah, from the chair, when we were approving the time limit on expense voucher reimbursement, you had said for on a going forward basis, so there's a new, but I didn't see that in the proposed rule.
These rules are well, I'll let Mr. Bainbridge address it in a second, but just so that we're clear, the intent was to put down the rules that would govern us going forward from the date of decision. Right. And so typically that's how we interpret, my understanding, when we adopt rules and regulations that are effective from that day on. They're not retroactive unless we specifically state that.
Yeah, that was our intent. So that's
Okay.
why we didn't include it.
Thank you.
All right. Any other commissioner comments? No? All right. Thank you, guys. Good job. Let's go ahead and move to item 17 then. That's the LLC discussion. Just to sort of frame this while everybody's getting seated, for several meetings now, commissioners have expressed some concern that LLCs that are participating in our state and local elections are not providing sufficient transparency with respect to who the folks are that are managing and making decisions with respect to their political activity, and also with respect to the sources of money that those LLCs are using. So we directed staff to go back and take a look at the state of the law currently, both from the standpoint of what we have done in terms of regulations, what we could do in terms of regulations, and then identifying the limitations, if any, with respect to our regulatory authority, where if we wanted to do something more to address this issue, we would have to seek legislation. So today, what we have is a staff report that gives us that type of background, lays out, to my understanding, what our regulatory options are. It also identifies pretty clearly to me the areas where we can't go any further absent additional statutory authorization. And so once we're done with staff's presentation on the regs, we would then transition to a discussion on legislation. And Mr. Ung can walk us through the status of our LLC legislation and get some additional direction from us on that issue as well. At the outset, though, my understanding is that staff has a presentation that helps us tee up both the importance and what the issue and the problem is with respect to LLC.
Yeah, I think Torrin thought he had more time when you skipped over his item. He just left the room. So we'll get set up from a technical standpoint, and then we'll.
Five-minute break?
Sure,
We can take five.
you can take 5.
All right, let's go ahead and start back up. Mr. Lewis, welcome back to the table. Sorry, I know I threw you for a loop by taking that one out of order there.
Not a problem.
All right, so go ahead.
Great. All right. Thank you, Mr. Chair and Commissioners. So Torrin Lewis, Commission Counsel with the Legal Division. At the Commission's request, we've prepared a memo that you should have summarizing our research regarding the lack of meaningful disclosure with respect to LLC political activities in California, and that's a limited liability company political activities in California, as well as some possible legislative and regulatory solutions for discussion. Because it was easier to actually just prepare regulatory language for discussion, we've actually prepared some draft proposed regulations for your consideration. So what I'd like to do now is do a brief overview via PowerPoint presentation of our findings, as well as the proposed regulatory approach to addressing some of those problems. And I'll defer then to Mr. Ung here to discuss the status of the legislative approach, which we can then discuss at that time as well. Great. So if you'll pardon me while I swivel here to face the monitor. So as you are well aware, the purposes of the Political Reform Act include truthful disclosure of money spent in our elections, and that includes clearly identifying contributors on campaign advertisements. The purpose of the campaign provisions is to provide information to voters so that they can be informed as to who is funding campaigns or opposing campaigns where they live, and hold violators of the act accountable for non-compliance. Limited liability companies pose some problems to achieving those goals of the act, in that in California, as well as many other jurisdictions, corporation laws don't actually require a natural person, that is an individual, to be listed on any of the LLC formation or registration documents. And so that includes the LLC's owners, its investors, managers, agents. None of those required positions actually have to include the name of an individual. In fact, an LLC can list, for example, as its registered agent or as its member or manager, another LLC in another state. And sort of compounding these problems in the election context is that California doesn't require disclosure of an LLC's managers until 90 days after it has been formed. So you can imagine if someone were to form a new limited liability company shortly before an election and then use that LLC as a vehicle to make contributions or expenditures in an election, the electorate would not know who is affiliated with that entity until, at best, 90 days after that LLC was formed. And finally, on LLC's funding sources, or in LLC parlance, the source of its capital contributions, also do not need to be publicly disclosed. Added to that is the wrinkle of this industry throughout the United States that provides what are called aged shelf companies. And these are essentially pre-existing LLCs known as shelf LLCs that allow people to establish pre-established corporate entities to show longevity, corporate history, good standing, right? So they're up to date on their local filings and taxes. They have a clean history, and they appear to have been in existence, because in fact they have, but they're not actually owned by the same person necessarily who one might think. And so there's a number of companies that offer aged shelf companies, including this one pictured here based in Wyoming, just as an example. But as you can see, they advertise that they have an extensive inventory of aged shelf companies in 25 states throughout the U.S., including companies ranging from 1 to 12 years old, and that includes California aged shelf companies as well. So even LLCs that appear to be legitimate on their face could actually be bought for the purpose of evading disclosure and essentially misleading the public. And there's a number of companies who offer this service, not explicitly for that purpose in the political context, but, you know, for example, one could buy Microsystems, Inc., which is a New York-based shelf company, ostensibly. And for all intents and purposes, it would appear that this company is founded in 2008. It's 12 years old, and, you know, if you have the means for $16,000, that could be yours, and you could then use that to conduct whatever business you like in our state of California. So in the context of California elections, the Enforcement Division has pointed out a pattern of LLCs making large contributions and expenditures in our elections without ever having to truthfully disclose the sources of that money flooding into those elections. And in some cases, in fact, those LLCs were formed shortly before the election, which of course raises suspicions as to the intent of the creator. And, you know, in cases where this happens, currently there's no disclosure under the Act if there's under $1,000 rather in independent expenditures made, because they don't qualify as an IE committee, or under $10,000 worth of contributions, in which case they don't qualify as a major donor. And even where LLCs do qualify as major donors or IE committees, they're required to list their responsible officer, but often no natural person is disclosed to the public, since that term at present is not well defined. In terms of the extent of this problem, 8% of all active major state major donor committees and state IE committees are LLCs, right? So we're talking 218 LLCs out of all major donor and IE committees in the 2017-18 cycle, and 154 in the 2019-2020 cycle. So that's quite a number of major donor and IE committees that are LLCs that are potentially subject to this problem. So what can we do from a regulatory standpoint to address this problem? One option is to define who must be listed as a responsible officer for an LLC that qualifies as a major donor or as an IE committee. And specifically, we could define that that individual should be the individual primarily responsible for approving the political activity of the LLC, as opposed to, say, just a registered agent. Similarly, the Commission could require committees who receive contributions from LLCs to report the name of the individual responsible for the LLC's political activities as well. And as outlined in the memo and the proposed reg language, these options are not mutually exclusive. That being said, there are some limitations to these regulatory approaches. While they would allow the Commission to identify a natural person behind an LLC's political activities, the person pulling the strings or calling the shots, so to speak, this approach would not allow the Commission to get at the ultimate source of the money. And so this is important, of course, because in cases where shell LLCs are used to as a conduit for making contributions and expenditures in elections, the public in those elections, the voters, would still not know necessarily who, where that money came from, who paid to influence their election, even though the commission would have a person to identify and hold responsible for filing and reporting purposes. So with that, I'm happy to answer any questions, and I, of course, defer to Mr. Ung as to the legislative approach.
So, Mr. Ung, why don't you update us on the LLC piece of the legislation report now, so we can kind of take
in this issue, as we highlighted the overall general issue to him in previous meetings. So we're thankful for that. And the spot bill is what we call a substantive spot bill, as in if you were actually to look at the bill, it does make policy changes. It's not just a placeholder. And we did that partly because we wanted to make sure that there was no procedural speed bumps that would occur with the bill, because if it was a substantive bill, it would still move through the process. But Mr. Berman and his staff are also aware that of this meeting. They might be watching this meeting and listening to kind of what preferences the commission has in regards to what you would like to see in legislation. Torrin did a great job listing the possibilities of regulatory changes. However, I think the legal division will admit that those are somewhat limited to our current statutory authority. So pursuing legislation would really allow the commission to be more ambitious, to be a little bit more creative in the types of requirements that you would like to place and the type of information you would like to receive from limited liability companies or those committees that receive contributions or expenditures from limited liability companies. So that's the current status of the legislation, and I'm happy to continue this conversation with you.
Thank you, Mr. Ung. So I think at this point, it may be useful for commissioners if we can first focus on the regulatory piece and provide comments and guidance to staff on their current draft language and things we may wish to see added to that. And then we can, once that's complete, move on to give additional direction on the legislative front. So commissioner comments on the regulatory options. Commissioner Hatch.
Well, I should start by saying good work so far. This is a tricky, I know that, to my knowledge, there's no limit on how many LLCs you can stack one upon another to accomplish this. So it's almost, the information that's currently disclosed, if and when you get it, is meaningless in terms of, what it is we're supposed to do with guarding against inappropriate contributions or independent expenditures. I'm not sure if some of the thoughts that I had are coloring outside the lines in terms of what our statutory authority is, but so I'm just going to kind of put them out there, and you can tell me that that's something you got to do in the bill or whether or not it's something you can do in disclosure. And I'd like to borrow from a personal experience myself. I had established an LLC a long time ago, and because of the federal laws require banks to know their customers and know that in very specific terms, in terms of federal regulations, they were allowed to, pierce any, veils and require specific information as to the real party of interest are. And so my thought was, if we require the recipient to know their contributor in the same sense of the things you need to know, where'd the money come from, who's got the decision-making power, which you've already covered, because they're in effect kind of like an intermediary, sort of a super intermediary. They're receiving money from an undisclosed source and then carrying out either making contributions or doing independent expenditures. But I think that that's, if to the extent that we can do that under the existing statute, I'd love to be able to pursue that line. To the extent that we bump up against a problem with the statute, then I encourage us to then try and work that into what I used to call a semi-spot bill that you described. And then, of course, there's, I suppose, some potentially, my thought is here that you don't get to cash the check until you've received the information that you can then disclose, as opposed to this current 60-day rule. You put it in and then return it 60 days later if you can't figure it out. You could easily create a pattern where people are making contributions to candidates, 59 days before the election, and they get to use the money, could aggregate into sizable amounts of money with a web of LLCs, and that just gets returned after the election. And there's always lots of, if you win, there's lots of post-election money available from other contributors that don't mind disclosing who they are. Those are my 2 bits. Thank you, Mr. Chairman.
Additional commissioner comments?
I have a question and a comment.
Commissioner Hayward?
Thank you. I have a corporate law question, which you may or may not be able to answer, and in my copious free time, I could probably look up, but I haven't yet. On the slide on page 3, where we say that California law does not require disclosure of LLC managers until 90 days after formation, do you know what the similar time frame is in, like, the really popular LLC jurisdictions like Delaware and Nevada? Do they even require disclosure of managers?
That is a great question. I do not know.
Well, because that's the thing, is I think we also need to be mindful of the fact that we've got, at least 50 jurisdictions that can, give birth to these things, and that that the race is going to be to the one that's least demanding. I thought it was interesting on the slide with the Wyoming Shelf LLC that one of the things they were highlighting is that they avoid the Nevada stigma.
Yes.
Full disclosure time, I manage a Nevada LLC. I do. It's a family thing. It's to pool some investments, but it's really easy to make one of these, and I understand that completely. And then the other question I have about that same slide, if you form an LLC, can you dissolve it before the 90-day, disclosure and just basically treat it like it never was there? Or is there some continuing obligation after the 90 days to disclose who your managers are?
Again, that's a great,
Okay.
great question. Yeah, I could check with SOS about that.
Yeah, those are
in the
sort of
California
out of left field kinds of questions, but, let's try and be as imaginative as the people who use these tools and think about how that might work. And then as far as, I'm intrigued by a requirement similar to the Know Your Customer requirements. I'm not sure. Part of this that I guess I'm kind of hanging up on is there are lots of entities that are LLCs, and not all of them are these fly-by-night tools for avoiding disclosure. I think Comcast is technically an LLC. Zuffa, which is a very politically active LLC, if you look at CalAccess, is ultimately the ultimate fighting mixed martial arts people in Las Vegas. Well, it's super easy to figure out who those guys are, right? You put Zuffa in Google, and the first thing that comes up is the identity of the donor.
Right.
So those aren't the problem. And I'd hate for those guys to get wrapped, who are playing it by the rules and doing what they're supposed to be doing and participating in politics in California in the way that we let them, and that's fine and good. I don't want to come up with a rule that makes their activity overly weird or burdensome, or asks them to do things that they really aren't able to do. It may be that they can't get the signature of the person who's making the contributing decisions on a form because that's maybe a board instructs somebody in some lobbying division to work with somebody else, and it might be a little attenuated. And so, we might come up with a rule that they look at and go, well, we have no idea what you want us to disclose, because they're big. They're not the little fly-by-nights. And kind of, overlapping that issue, I think, is the fact that we've got multi-purpose organization rules for big entities that do a lot of things, some of which is politics in California. And I don't understand right now how those existing rules might overlap with the larger LLCs I'm talking about, or not. I mean, that is the thing that's confusing me right now, and it's something that came up real quickly in the law and policy call. A member of the regulated community said, well, aren't these kind of analogous to multipurpose committees where you should be? And I'm like going, maybe they are. So if we could look at that and see if there's other places where maybe regulatory amendments could be made that would help in this. But other than that, I mean, if all we can do in the regulatory sphere is pin a real natural person to the political activity of an LLC, I think that's really helpful. And it doesn't do everything, but it's better than where we are. And I think we should, not be dismissive of that progress. I think that would be really helpful. All right, thank you.
Additional commissioner comments? Commissioner Wilson?
This is a very informative discussion. Mr. Lewis, excellent, presentation. It really boils down to transparency. I mean, no matter what terminology you use, no matter how you look at this issue, if you are using an LLC as a basis to hide behind who you are in terms of making contributions, that's ultimately, just in layman's terms, what we're trying to address. And the regulatory route, that makes sense, providing, Mr. Ung, informs us that we're not going to be getting ahead of ourselves in terms of any possible legislation that might be, enacted or considered in the legislature.
Commissioner Cardenas, any comments?
Mr. Lewis, terrific presentation. Procedurally, what's the next step with this particular pre-notice? Where are we going after today?
Well, this wasn't technically a pre-notice. We weren't instructed to prepare regs. We just did that because Torrin's an overachiever, and we thought it would be a lot easier to not talk in the abstract. That being said, if the commission would like to move these forward, we could notice them in anticipation of the meeting in May for adoption. We would essentially be skipping the so-called pre-notice, treat this consideration of them as the pre-notice. We would then notice with OAL, and then we'd have the 45 days. So we could bring these back as early as May for adoption. Or we could bring them back again next month on pre-notice, and then it would be June for adoption.
Can I ask a point of clarification? Our agenda, item 17, notices this as pre-notice discussion of proposed regs. I think you just said technically it's not pre-notice, so what makes it technically not pre-notice even though we agendized it as such?
Just that the original instructions on this item were to come back with a memo exploring the options. But I think you're right that the agenda says pre-notice. The pre-notice isn't required. It's just the policy of the commission to typically do regs on pre-notice. So it's all just sort of a uninteresting technicality.
Okay. All right. Did you have more?
This is the type of space that I think would warrant some public comment, maybe significant public comment, depending on, I suppose, what is enunciated from here today. So, I mean, I realize kind of getting ahead of it, but it is helpful to understand how we are procedurally postured at the moment, because I did notice how it was noticed. So, having said all of that, Mr. Lewis or anyone else, have we taken occasion yet to consider the new and recent state of New York approach to LLCs, which is rather sweeping?
Yeah, and I think Phil may want to speak to this as well, because I know we both noticed that New York has recently enacted sweeping LLC reform, I think in the context of real estate transactions was sort of what that grew out of. But I'll be honest, we took a pretty California-specific approach in terms of looking at our statutory authority as it currently exists in coming up with the reg language, and mostly focused on the problem from the standpoint of some information shared with Enforcement Division that we highlighted in the presentation about the trends here in California. So we did see it, but it was not inspiration for these proposed regulations specifically, since it, like you mentioned, it was a much more wide sweeping approach.
Can we go to the last, your last slide? So the first bullet on this slide, the focus could be on transparency and disclosure and with respect specifically and even only to who or what is the face or the entity of the LLC for Secretary of State purposes. Right now, it, as you correctly stated, it could be another LLC, it could be a company. That's one of the beauties of the limited liability company. And when I was practicing, I would, in terms of a choice of entity, I would need a real good reason to suggest to my client that they should incorporate or establish themselves as anything other than an LLC. Not because of this, but because of the flexibility that it affords in California in particular, and somewhat less paperwork also. For example, you don't have to have an annual board meeting, as an example, and for some people that's a hang-up. So I understand the opaqueness in connection with this particular type of entity. So what we're talking about here, or at least one option that's been presented to us, is to have a little bit more clarity with respect to who is the face, if you will, of the LLC. One option is it could no longer just be some other entity. It must be a live human.
That's right, Commissioner. And in addition to that, I would add...
Or at least the name of a live human.
That's right. And not only of a live human, but of a human who is actually involved in directing or controlling the LLC's political activities. Because even in instances where an LLC does name, say, its attorney or its public accountant presently as its agent, that often won't capture properly who's directing where the LLC's money should go for election purposes. And so I think to provide voters with that information, that was sort of the idea behind making it a person who is overseeing the political activities.
That's brilliant, and that gets me to, I mean, I kind of hate to switch.
Oh, no.
Gets me to, is it Assembly Member or who's, Berman?
Berman, Mr. Assemblymember Berman.
Sorry.
Yeah, that's okay.
Apologies. Assemblymember Berman, this bill that was introduced, I guess, just 2 days ago. Mm-hmm. The way it's worded right now, it's almost as if the reporting committee could choose between the identifying who owns the LLC or who controls its political activity. I mean, if you read the language right now, I understand it's their first cut, but if you read it right now, and I don't know where I put it, it could be read to mean that they must identify under this bill, if it became law, they must identify the individual, presumably a live human being, the human being who owns it, and then there's a comma, and then it says, or controls the political activity. And that's a huge difference. So
Yeah.
The author, and we might want to suggest that there be some clarification there.
Just for clarification, the spot bill right now, I believe should be read in the conjunctive, which means that both of those things would have to be disclosed.
They'd have to
Yeah,
disclose
there's no
both.
or, it's both of them, as phrased right now, but again, it's a substantive spot bill.
So if there are multiple people, then they must list. Is
You
that
would
right?
have to name the owner or operator of the LLC and the person who's responsible for contributions or expenditures. Maybe the same
For
person.
controlling, yeah, right.
I would also would want to point that the current bill's language is very much placeholder language, and that Mr. Berman and his staff are very much open to hearing what the commission would like to see and working with us in either replacing that language, enhancing that language, whatever the next step is. And so what's currently their first shot was in consultation with me in a way for us to say, look, this is an LLC-related bill so that people are on notice that there's an LLC-related bill that's moving, and still substantive enough that it could get through the first policy committee in April, and still kind of be germane to the issue if we were to substantively amend it in April or May. And that's the difference between a semi-spot or a substantive spot bill and a real spotty spot bill where it's just like it's the intent of the legislature to do this. Those spotty spot bills don't move in the legislature at all. And so what we were trying to do was make sure we have a vehicle that builds us time as a legislature or as a commission to really work through this detailed substantive policy that could take months for us to really massage and get right.
My understanding of the New York bill is that contributions made by an LLC starting a little over a year ago when the law took effect are attributable to the members as legally defined members, being the corollary of shareholder in a corporate context, right? Member with a capital M, those who have, for lack of a better word, an equity position they actually own the damn thing, right? That contributions made by an LLC are attributable to the identified members proportional with their membership interest stake. So if there are 4 owners, quote unquote, of an LLC and they're each equal 25%, any contribution made by the LLC then is booked as 1/4 of the contribution came from member A and then B, C, and D. That's what as I understand it, makes the New York approach pretty sweeping. And I think I read that it rose out of a real estate context because it's the classic LLC real estate serial things that were going on. But I don't understand the New York approach to be limited only to REIT or other real estate type of LLCs. But it's another approach which gets to the source of the money limitation that you point out. I'm not suggesting it, but I do think that it's a live wire for consideration.
Yeah, and just to chime in, Commissioner, I wasn't suggesting at all that I was against that approach or I didn't think it was a good idea. I think that's probably something, and both Phil and our general counsel can chime in if they disagree, but I think that would probably require a legislative approach to arrive at that sort of solution, which is why we didn't look at it from the regulatory angle. But I definitely think in terms of it sounding effective, I think it sounds worth looking into, and I don't know, I defer to Phil as to whether that's going to be part of the legislative approach, but just wanted to throw.
All right. Thank you. Commissioner Hatch.
Is a requirement that you return a contribution that the information is not properly provided, even from an individual, must be returned in, I think, 60 days. Is that statutorily based, or is it just a regulation?
So I do know off the top of my head that I believe that requirement's found in Regulation 18570.
Is that based on a
yeah.
statutory specific
I don't know a specific statutory section that that's based off of.
So we then presumably would be able to set a different standard for, in other words, be able to require them to simply not cash it until they know the information, as I was talking about earlier, about knowing your contributor. You think that's correct? Okay,
Yeah, I believe so, yeah.
thank you.
So, Mr. Lewis or Mr. Bainbridge, whoever wants to take this one, you guys can. So my understanding of the current proposed draft language is the approach in terms of, with respect to committees and their obligation. If a committee accepts a contribution from an LLC, we are requiring them to collect from the LLC some live human being's name who is designated essentially as their principal officer, et cetera. And we're using our existing regulation, which requires that for normal contributions under sort of the purview of name, occupation, employer, et cetera. So essentially, we're saying this is the name that must be provided. Is that correct?
That's exactly right.
And so that gets to that would then give them 60 days to receive that information from the LLC, or they'd have to return the contribution.
Exactly.
Okay. All right. With respect to the regulatory options, I think I have a couple thoughts. First, sort of big picture, I think to Commissioner Hayward's comments, in my mind, I draw a very principled distinction between corporations and decisions of actors to become an LLC. There are all sorts of business reasons why folks may want to be an LLC. And quite frankly, I would just point out that even though I know we use the shelf corporation where you can buy a corporation that's been in existence for a long time, there are valid business reasons why folks would do that. So this presentation is not intended to cast aspersions on folks who do that as a matter of business practice. I think, to me, the principle that we should be concerned with here is when those business actors choose to engage in political spending in California, in state and local races, because, by the way, those numbers we got were just the state races. We have other evidence that this is happening at the local level, too. So the problem's even larger than the information that was presented there. When they do that, they become subject to our jurisdiction, in my mind. Now they're playing in our elections. And we have, I think, an obligation to increase transparency there with respect to who the people are involved and where the sources of money are. So when it comes to these regs, my sense is it was noticed as pre-notice. We should treat it as such. Proceed, I think, Mr. Bainbridge, you said May is when we could adopt under that schedule?
It would be April if we treat this as the pre-notice.
I would like to see us make the best effort we possibly can to get these regulations consistent with identifying a person and both from the standpoint of the LLCs that are participating and the committees that are receiving those contributions, get these regs in place no later than May. That gives 6 months before the general election for folks to comply with that, and I think it's important that we try and do that before the general. I think in the interim, I would encourage you to perhaps consider holding an IP meeting at a minimum on this. And I think this is something also that we should hear in law and policy, if not once, maybe twice over the next couple months, to continue receiving public comment on this, because I think it's a valid point. I mean, there's different ways of approaching this. Maybe the multi-purpose reg makes more sense. I don't know. It's a good discussion for us to have. But I think this is a critical issue for us to be focused on from the regulatory standpoint. So do commissioners have any thoughts on that proposal, that we try and shoot for May as the latest in terms of adoption on the reg proposals?
I tend to agree. With reference to the stacked LLC issue or stacked on top of corporations, that we figure out a way to require that the duty to chase the real people can proceed through multiple entities if we require them to the recipient to get this information. And I don't know how other folks here feel, but I really think it's a good idea that the regulation, to the extent that it can be done regulatory, that the duty is to get this information before they deposit the contribution. Because otherwise what we've done is sort of meaningless, because this money comes in late typically, and it means it's like a loan, you know. you get the money, you deposit it, you buy your TV time or whatever it is, your postage for your next mailer, and then the election's over, and then you have a quick fundraiser and repay all those contributions that were made inappropriately.
Additional commissioner comments?
Yes, Mr. Chair. Yeah, I would agree with the comments made by the chair. And also, following up on what Commissioner Cardenas had said earlier, to look at New York and see how actively the LLCs oppose the legislation in New York, because that'll probably give you a good indication of what we can look for in terms of opposition here in California. And then just from a pragmatic standpoint and using just common sense, in terms of the source of money, we don't know this for a fact, but the recipient in many cases may very well know who's behind the LLC. So transparency is very popular in this era, and this goes to the heart of transparency, and I think we ought to look at regulatory options as long as they're not in conflict with any legislative solutions.
I have
Commissioner
a
Cardenas?
question. So 8% of all active major donors and IE committees are LLCs. That's gleaned from the Secretary of State. Is that right?
That's right, and those are state IE committees and state major donor committees.
Okay.
And that data was collected in early January. So as we got closer to the March election, I'm sure that number has increased and will increase as we get closer to November.
That's the number of the entities. How about the percentage of dollars?
That was a deeper dive into the data that we didn't want to burden the Secretary of State with, but I think we could inquire of that information with them to see if we can get that. But I think initially we just wanted to get the number of entities that we were, kind of the universe of entities that we were dealing with, to see the extent to a potential problem that we may have. But I can double check with them.
I recall a recent discussion where it was represented that that particular office over there at SOS is somewhat under-resourced. So it's understandable not to overtax them, but if there's the opportunity, that would sure be helpful. By the way, just because I'm looking into the screen and I am referencing certain things that I see from this particular screen, as a matter of full disclosure, what I'm referencing here is apparently the New York State Board of Elections. The New York State Board of Elections, which has information about their brand-new LLC approach, just so that anybody watching knows where Cardenas is getting this information for, and for staff to begin to, that might be a good place to start. And to my fellow commissioners' question, who in New York opposed this approach as they were contemplating it, and I gather it was a rather hot and hairy issue in the state of New York, as one might imagine. We might anticipate some of the same pronouns showing up at our IP hearings. I'm just throwing that out there. I think that's it for now.
All right. So to conclude on the regulatory front, before we go to Mr. Owen and give you some additional direction there, I hear a consensus among the commissioners for, I think, 4 things. Number one, that we try and conclude our regulatory work with respect to LLCs by the May meeting at the latest. So we have 6 months before the general to have those in effect. Secondly, I think I hear consensus, broadly speaking, that you should continue working on and refining both approaches you've laid out in the regs, mindful of the fact that there may be some options embedded within each of those approaches that you may want to come back with. Commissioner Hatch, I think, has mentioned perhaps instead of giving a period of time to return a contribution from an LLC, instead straight up say you can't accept it unless you have this information up front. So that should be an option that you consider and bring back to us. That we examine, as Commissioner Cardenas and I think Commissioner Hayward suggested, other states and other approaches that they've taken there to see if there may be additional work in terms of the regs that we can do, as long as it's not in conflict with statutes. And then finally, that you have at least one IP meeting on this and that we will be hearing this in law and policy at least once, if not twice, to gather additional input. Did I miss anything in terms of Commissioner Hatch?
You didn't miss anything, but summarizing it as you did made me wonder if there's anything in our existing regulations that would currently limit how long a recipient could hold a contribution without depositing it and be in violation of some existing rule or statute. You don't have to answer now, but it's something you should figure out and consider. So we'd have to hop over that if we considered an option to have them hold it. Thank you.
Good point. All right, at this point, I would call for, is there any public comment on the regulatory proposals that we've just discussed and the direction we've just given on the regulatory proposals? Seeing none. Let's go ahead and proceed then to commission discussion and direction to Mr. Ong on the legislative piece with respect to LLCs. And to sort of tee this up, I know we have talked to Assemblymember Berman's office specifically about our thoughts on improving disclosure of the human beings behind LLCs and their participation in spending. What I don't think we've done yet is get clear direction from the commission that in addition to that, we want to also see what options are available to get at the sources of money that LLCs are using to contribute to state and local elections in California. So I just wanted to give the commission an opportunity to provide that direction to Mr. Ong so we can then communicate that as an additional piece of the legislative package to Assemblymember Berman. Anyone disagree that we should give Mr. Ong that direction?
Yeah, that's fine.
Okay. Mr. Ong, anything else that you need from us then?
I'd like to follow back up on some of the discussion that occurred during the regulatory discussion that kind of bled into the legislative discussion.
Sure.
I think what Commissioner Hayward brought up in regards to the law and policy meeting and a public participant bringing up the MPO or the multipurpose organization rule. Just for context for the audience, the current multipurpose organization statute specifically exempts business entities. So that is why we can't use 84222 and apply it to LLCs. In addition to it being specifically exempt, I know some folks thought, well, why don't we just cross out the exemption and just have them included. I'm not sure that model works either, partly because the MPO rule is written in a way to respect both nonprofit tax law as well as other associational rights that nonprofits have in regards to protecting donor entity. And this is where I get a little bit out of my comfort zone and start talking about a little bit about constitutional law. So maybe Commissioner Hayward give me a little rope here, but I don't know what the jurisprudence is on constitutional protections for LLCs and their associational rights. And so perhaps we could be more aggressive than the MPO rule as it relates to LLCs in getting membership identities like Commissioner Cardenas mentioned. Because I know in the MPO rule, they were very careful about, okay, we don't want to just capture every donor because not all of them gave in solicitation to a political contribution or knowledge of political involvement, that they just supported the organization in its mission. So Commissioner Hayward didn't shake her head at me, so I think I was okay there. Another point that I realized as the commission was talking is that I think there's a real realization that corporate law has some friction with political law, and especially the Political Reform Act. And corporate law doesn't serve our purposes in their timing, the 90-day statement of information, or any of those things. And so we just cannot depend on California's corporate law or any other foreign LLC's corporate laws to help us in this instance. And so we really need to, I think, buff up our statutory authority on this matter. And the last thing that I would mention before I take further questions from the commission is that the regulatory approach that Legal Division has proposed, I think we can also include in a statutory proposal. I have no doubt we have the statutory authority to adopt these regulations, but I think it gives us a little bit more authority and meat if it's in a statute seeking the type of authority that we're seeking here in regulation. And so that would be my last comment in regards to the legislative proposal.
Mr. Rob. Commissioner Hatch?
Just one additional, I would encourage you to the extent that any of our suggestions bump up against a statutory limitation, we'd want to consider including that in your bill proposal.
Any additional commissioner comments from Mr. Ong on the legislative piece? On LLCs? All right. Any public comment on the legislative discussion on LLCs? All right, seeing none. At this time, we have a closed session on our agenda, and I understand that Commissioner Hayward needs to leave a little early today. So I'd like to, at this point, move to closed session. Thank you guys for great job on the LLCs, and we'll be talking to you more about that in the next few months. So let's go ahead and, now that we're done with 17, let's go ahead and move to closed session, and then we will take a short lunch break after that. So perhaps reconvene at 1 o'clock to the executive conference room. All right, thank you. So we'll reconvene at 1 o'clock.
We're sorry. Your conference is ending now. Please hang up. There are 1 participants on the call, including you. To request a specialist, to place all participants.
All right, we'll go ahead and we will call item 20 back, legislative development. Ms. Strong, welcome back to the table.
Thank you. Thank you for the lunch break.
You got it. We knocked out the LLCs, so why don't you go ahead and take us through your ledge report then?
Yeah, thank you, Chair Matich. As the report states, that we are still working with stakeholders on the sponsored legislation from last year, Senate Bill 423. Part of the hiccup is the folks we need to talk to are quite busy with the March 3rd primary. And so we have decided not to sit down with and talk to them until they've gotten past the primary election. That timing works with the Assembly Elections Committee, who has confirmed that they didn't really plan on setting the bill until June of this year anyways. And so if we can sit down with those stakeholders and work out an agreement and propose proposed amendments to the commission in April, that would give the committee enough time to look at the bill and evaluate it at that time. So that's the timing that we're currently working on that one sponsored piece of legislation. As far as legislative development, I did update you on the limited liability company spot bill. Assemblymember Berman is also authoring our unlawful personal use of campaign funds bill. And so he's really stepped up this year, so we appreciate his authorship on two of those high priority topics of the commission. The use of public funds, we have secured an author. We are still working through some of the language details with them, and so we expect that come this Friday, there will be a spot bill introduced as it relates to that piece of legislation. And we'll continue having discussions with them through March. Another confirmation that I can provide is that Assemblymember Mullen has agreed to carry cleanup legislation related to Assembly Bill 571, which is the bill last year that adopted local default contribution limits. It's a pretty big bill, and we found some issues with it as we were starting to implement the bill, and he's decided to carry cleanup legislation on that. And the last matter that's not in the report, but I'll report verbally if that's okay, to the commission is we have found an author who has committed to carrying the bill that would require mandatory e-filing of Form 700s. We're working through some of the details with them, and so we expect a spot bill to also be introduced on that matter this week as we work through some of those additional details through March. And so that is part of the reason why this legislative report wasn't updated post-notice, is because every day there seems to be a new development. And so if I was to update this report, it would almost be out of date immediately. But from a verbal update standpoint, this report says there were 3 active political reform bills as of February 10th. It's now February 20th, and there are 8 active political reform bills. So that's just an example of how fast things move. It's almost a bill was introduced every day since notice. And the bill introduction deadline is tomorrow for the legislature, so we expect to see a lot more Political Reform Act bills introduced starting tomorrow. I feel like I have a pretty good grasp of everything that everybody's been working on, but as Commissioner Dotson and Hatch can testify, that sometimes people don't give you a heads up before they introduce bills, that they will just introduce bills and then give you a heads up afterwards. And so I'm also on the lookout for those pieces of legislation. And at this time, I don't have any other comments about any other bills that are pending, and happy to take any questions.
Commissioner Hatch?
Question on the bill that would require e-filing. Would that apply to local agencies and state agencies?
It would not. We're really, well, yes. I guess that's the careful thing. So essentially, what the bill proposes is that anybody that's currently filing with us would have to file electronically with us.
Okay. Directly with us, yeah.
Directly with us. So that would include some elected local officials, the mayor, city council, city attorneys, district attorneys, those type. And so, but it doesn't include all designated individuals at the local level. That would be outside of our current scope. We don't currently accept those filings. And so we didn't want to kind of make that additional leap at this juncture. Although I think some staff would like to, it's just at this point we didn't want
So
to.
anybody under a local filing officer, this doesn't apply to?
That's correct.
And not state agencies who do their own administration of Form 700?
That's correct.
Okay.
Yeah. Yep. we tried to keep it within our current universe. If they're currently filing with us, if we're their filing officer, that's who has to file with us, who's going to be required to file e-filing with us. Yep.
Quick question. Is there any legislation that we're actively opposed to at this stage? Or is it, or we're just looking at legislation that the FPPC supports?
There has not been any legislation that has, well, I can't speak on opposition because you all have to take a position of opposition, but has raised my eyebrows that I feel like at this particular juncture of the session, that I would need to raise to your attention. Partly, as you know, Commissioner Wilson, with the introduction deadline being tomorrow, all bills have to sit for 30 days before any action can be taken on them or any amendments can be made on them. So we really want to see kind of what the universe is like. And then really at the March commission meeting, we'll have a better picture of what bills are out there. And we'll be able to collect information from the offices about what the purpose and the intent is of some of the bills.
Just kind of a technical clarification. I know you're familiar with this, but for the benefit of the other commissioners, in the Assembly, but not in the Senate, after a bill's introduced, a bill can be amended in an Assembly committee prior to the committee hearing.
That's right.
But not in the Senate. So a bill could be amended a week after it's introduced, within that 30-day limitation on amendments, but only in the Assembly.
Yeah. No disagreement there with the former parliamentarian.
Thank you.
Yes.
Oh, good job.
Thank you.
Any other commissioner comments on the legislative report?
I do have one.
Commissioner Cardenas?
Mr. Ung,
Yes, sir.
it's 300 Umberg,
Yes, sir.
SB 300. Two questions, if you don't mind. One is, where does that appear to be now? And secondly, how, given the federal prohibition on foreign contributions, how does this change anything?
Yeah, so this bill is still in Assembly Elections Committee. It crossed houses from the Senate over to the Assembly. It got assigned to the Policy Committee and has been sitting there since May of last year. On purpose, Senator Umberg has chosen not to move the bill forward. I believe he plans on moving it this year. But with some amendments, I just don't know what those amendments are yet. As it relates to your second question, as it relates to the federal prohibition, this is a bit of gilding the lily. There is a federal prohibition on this. However, the Federal Elections Commission enforces that prohibition. And I think the state legislature has expressed some interest in having the FPPC enforce this in the absence of the FEC not enforcing federal law because of, for example, lack of quorum.
Can you speak to the prospects of this? A similar or identical Ridley Thomas bill died 3 years ago, apparently?
Yeah. You know, it's hard to tell. I mean, the 2016 bill, the politics were slightly different. The messaging was slightly different. We worked closely with Assemblymember Thomas on that bill, and I believe it died in appropriations. And so I think it was a fiscal issue ultimately. Of course, it could be a political issue. I've heard some discussion among staff informally, so I can't quote them on the record with names, but that anything that deals with the citizenship of donors is kind of a hot topic in the legislature, especially in today's political environment. If that makes sense. That's as much detail as I can go into.
May I follow up? Mr. Ung, this, I guess, the original bill for that change to the Political Reform Act that prohibits quote unquote foreign originating contributions, if I can use that term, from ballot measures, from state and local ballot measures.
Correct.
Do you happen to know or recall why the legislature saw fit to distinguish, if it was a legislative act, it wasn't a referendum, I guess.
No, it wasn't.
Why the legislature saw fit to apply this prohibition to ballot measures but not to candidate elections.
And I think part of that was because there was a gap in federal applications. The federal law didn't apply to ballot measures because the federal government doesn't deal with ballot measures. And so there was a gap in enforcement as relates to how foreign contributions applied to ballot measures. So they closed that gap. Yep.
Any additional comments, questions on legislation? Thank you, Mr. Ong. Appreciate your work. All right. Well, then we start taking things out of order. So quickly, we'll just go back to item 18. This is the update on the Digital Transparency Task Force. Commissioner Hayward and I discussed this at the Law and Policy meeting. We approved the basic parameters of the composition of the task force. We've had staff reaching out to specific individuals who have expressed an interest in serving on the task force. We're receiving their responses currently. So that seating the task force is in progress. We have a tentative first meeting for the task force of March 10th. That may be aggressive, but that is certainly the date that we're currently operating under, and that's the date that we're talking to task force members about. I'd like to report that the Secretary of State's office, I recently had a conversation with their office, and they are excited to participate with us on the task force, and we'll be sending a representative. So we certainly appreciate that and look forward to working with their office. I think it's a natural area for us to be collaborating on. And then I think the final thing I wanted to say about the Digital Transparency Task Force is, you know, nary a day goes by, I feel like I don't read something in the newspaper that raises another issue that really drives home the need for us to focus on this area. And I would just mention that, you know, the other day there was something in the papers about how certain federal candidates are paying social media influencers to post content on Instagram. And it's clearly not being attributed to a particular campaign. It looks like somebody is just posting and sharing information on behalf of their preferred candidate. I know I've had some discussions internally with our staff. I'm happy to report that at least in California, I think the payments for that type of activity would likely be disclosed. But one of the remaining gaps and something that we're going to be focusing on with the task force is how do we get to the actual content that's being paid for before the public? So they have a place to go where they can see that if something's on social media, that's actually a paid ad and not just somebody's opinion. So it reminds me that it continues to be relevant. Today, Commissioner Cardenas, I know you distributed an article about political ads on Hulu and Roku and other streaming services. This apparently is another gap that is not picked up by federal law. So again, within the ambit of our task force, I think that's something that we can sort of pick up the ball and start working on. So appreciate everybody supporting the work of the task force and look forward to getting that started here in the near future. So that's the update on the task force. Chief of Administration Hahn, item 19. Care to take us through the second quarterly expenditure report?
Good afternoon, Chair and Commissioner. I'm here to present second quarter expenditure. Quarter ended on December 2019. Budget expenditure is in line with our projection of allocations. And I'll submit it as is unless you have any questions for me at this time.
Any commissioner questions, comments? No. Commissioner Cardenas? Commissioner Hatch? No. Nope. All right. Thank you, Ms. Hahn. Appreciate it. All right, we can now move to committee updates. Item 22, in Commissioner Hayward's absence, I can tell you that we had a law and policy meeting on February 5th. We received some information on the scholarship fact sheet that the commission had directed staff to prepare and publish on our website. That has now been done, so thank you to the staff for that. We had the Digital Transparency Task Force, I just mentioned that, so we were able to take some information and make decisions there. With respect to the legislation that was presented to us, we heard updates on LLCs, personal use, misuse of public funds, and other FPPC initiatives. And then the final thing that we heard in law and policy was the sponsorship reg, which we've been working on for some time, originally started by Commissioner Hatch. And at that meeting, we received significant public comment from stakeholders, others, with respect to staff's proposed reg. And what Commissioner Hayward and I took away from that was that we think that additional work needs to be done with respect to the sponsorship reg, and in fact that perhaps the best approach with respect to that issue is examining a statutory change, because we keep coming back to we can only go so far with the reg. The reg becomes increasingly cumbersome, increasingly convoluted. This is something that I think we might be able to do better through a statutory change. So that was the position taken by the advisory committee at that meeting. We'll continue to have advisory committee meetings over the next few months to receive updates from our legislative director and receive input from him as well. So, Commissioner Hatch, I see you.
Just a question. I think it's a previous agenda. It showed, I thought it showed that this was going to be taken up at the March meeting, but now I don't see that in the staff reports. It's not listed at all, that reg. So is that?
Have the sponsorship reg come back to the March meeting? Is that what you're
I thought
asking?
that it was put over to March at the request of the committee, but in the executive staff reports, I don't see it listed at all for any month. So is it just, was your action to just simply not bring it back to the commission?
No, I believe our action was to have a refined version of the regulation brought back at a subsequent meeting, and to pursue some additional legislative approaches to resolve the issues that stakeholders are raising. So the bottom line is, it will come back to us at a
point,
future
but it's
meeting,
not-
but in a different form than it was presented in LPP.
But in a timeline that's apparently not decided yet.
I don't know, Mr. Bainbridge, do you remember whether we were going to bring that back in March or whether it was after March?
I'm trying to remember if we had an exact date established for bringing it back or not. I don't recall off the top of my head.
I mean, I don't
That
see a
may
reason
be
we
why
couldn't
it's not
bring it
in the
back in March, at least for an update on where we stand with that reg.
We'll work on bringing it back in March, as long as it's ready.
I just want to know when, because it wasn't on your report.
Yeah, I think that's an oversight in the report, that
Okay.
we should have listed it somewhere. I just don't remember right now what month we had decided on.
Okay,
Thank you both.
all right, thanks. All right, the other item that I wanted to bring up under committee updates, we have two existing ad hoc committees, our Law and Policy Committee and our Budget and Staffing Committee. I think we should give thought, and I'd ask the commissioners to consider today approving the creation of two additional committees. The first would be a litigation advisory committee, and the initial charge for that committee would be to work with staff to develop procedures and policies for commissioners to receive information and provide direction when there's substantial litigation involving the agency or where the agency is named as a party, with the caveat that it would not include personnel related litigation. So this is whether there's a statute that we are in charge of implementing that has been challenged and we're named as a party, or one of our regulations is being challenged and we're named as a party. Those types of, I would say, substantial civil litigation. So I would ask the commissioners to approve the creation of that advisory committee today.
So moved.
Second.
Commissioner Cardenas?
Yes.
Commissioner Hatch?
Aye.
Commissioner Wilson?
Aye.
Chair Matich?
Aye.
The motion passes.
As the second portion of my motion, I would ask that Commissioner Hatch be nominated to serve with me on the litigation advisory committee.
So moved.
Second.
Ms. Linker?
Commissioner Cardenas?
Yes.
Commissioner Hatch?
I'm not sure if it's appropriate for me to vote or not. Aye, if it's acceptable.
Commissioner Wilson?
Aye.
Chair Matich?
Aye.
The motion passes.
The second advisory committee that I'd like to commissioners consider approving today is technology and public outreach. I think that during my time here, There have been a number of occasions when we've had discussions internally about different technology issues or matters that need looking at within the agency. Many of those are related to public outreach. We recently, and you'll see later today, we're going to be putting out a public service announcement digitally, over TV, over radio, et cetera. There are technology embedded questions related to that as well as outreach. I know we've been presented with information on our new transparency portal for enforcement matters. That's the type of thing that I think, it would benefit from some input by one of our advisory ad hoc committees. And so I would like the commission to approve the creation of a technology/public outreach advisory committee today as well.
So moved.
Second.
Ms. Linker?
Commissioner Cardenas?
Yes.
Commissioner Hatch?
Aye.
Commissioner Wilson?
Aye.
Chair Manich?
Aye.
The motion passes.
As part of that, I would next move to nominate Commissioner Wilson to serve with me on the Technology and Public Outreach Committee. Do I have a second?
Second.
Ms. Linker?
Commissioner Cardenas?
Yes.
Commissioner Hatch?
Aye.
Commissioner Wilson?
Aye.
Chair Manich?
Aye.
The motion passes.
Thank you, Commissioners. I appreciate that.
Thank you.
All right. Advice letter report. Mr. Bainbridge, Mr. Lau, any advice letters you'd like to draw our attention to this month?
None of that I was going to draw your attention to, so I'm here to answer any questions if you have any.
Do any commissioners have any questions or comments on the advice letters?
I have a technical question. First of all, I commend you on all the updates and regular information that you provided the commissioners. But generally speaking, how many advice letters do we receive in a given month, just on the average?
It's about 15 to 20. I would say it's 200 to 300 per year.
Oh, okay.
So 15 to 20 a month.
Yeah, I was just curious. Thank you.
Any public comment on the advice letters? Going once, going, hearing none. Thank you, Mr. Lau. Appreciate it. Go ahead and move on then to our executive staff reports. Chief of Enforcement West, why don't we start with you?
As submitted, if there's any questions, be happy to answer them.
Any commissioner questions or comments? Well, I have a question. How's AdWatch going?
It's going well. It's not as busy as last year. I think it took everybody a long time to figure out that we were having a primary. And so now it's starting to gear up. TJ did remind me that I did want to report that Miss Susan Shelley has paid in full her judgment that you adopted a couple months ago. And that we have a tentative date set for the Albert Robles hearing, and that will be distributed to all of you to see your availability.
Excellent.
The one-day hearing that you all voted to take on. Commissioner Cardenas looks very surprised right now. For those of you who can't see it on YouTube.
That's to refresh our recollection, that was one of two administrative enforcement matters that we elected to hear ourselves as opposed to designate an administrative law judge to hear.
Certainly, and it's in Los Angeles. We are working with the Office of Administrative Hearings. They said they might have a room big enough, but they are happy if we find an off-site location. And
Big
we've
enough?
heard that you
this
you
a-
work somewhere that might have an accommodation.
What? A room big enough? Is this, are
Well,
we selling tickets or what?
So the commission and the ALJ will hear the case together. And so there has to be room for all 6 of you, plus the respondent and enforcement.
Yes.
I hear you have an office in Los Angeles, Commissioner Cardenas.
So we'll be talking about location and availability to make sure that the date that, because OAH chooses the date based on any kind of meet and confer that we did with the respondent. And so this is the proposed date is tentative as right now. And I believe Sasha is going to be distributing it to all of you to see your availability. June 8th, I believe, was the date. It's a Monday. A Monday in June in LA. It's like the beginning of a story.
This is a true story. I might honestly be on vacation with my family.
We'll
That date
work
is
it
not,
out.
so we'll have other options.
That is the
correct?
suggested date from OAH. So if we find a better date of availability for everyone, we will check with them to make sure that they also have the availability for that date.
Where's the meeting place? I mean, you said Los Angeles, but,
So at OAH, the offices are in downtown.
oh, the State Building?
And it's,
Probably the Reagan Building on Spring Street? Okay.
I know the picture of it, what it looks like.
All right. I just had a follow-up question on AdWatch. I know one of the issues you had raised with us previously was you were noticing a high percentage and a high number of the complaints that came through AdWatch were the result of the unique nature of our disclaimer laws, where political parties and candidates don't have to put disclaimers on some of their own types of campaign ads. And so, I believe some of that information suggests that there's voter confusion as a result of that aspect of our law. Are you still seeing that as part of the 2018 election, or excuse me, the 2020 election now?
The pattern's continuing. A lot of the AdWatch submissions are for candidate signs and candidate activity. And since the rules are different, then those are being rejected.
All right. And you'll continue to track that for us?
We will.
All right. Any further questions? All right. Thank you, Ms. West. Mr. Bainbridge, Legal Division update.
I would just point out, in light of Commissioner Wilson's question a few minutes ago about the number of advice letters, the specifics are contained each month in the advice report. This month, it's at the bottom of page 9. So you can see exactly how many requests we've had in a month and how many we responded to and that sort of granular information. Other than that, as submitted.
All right. Thank you. Good job. Executive Director Jones, do you mind doing your update now? And then we'll have Ms. Hahn come up because I think she has a video aspect to hers.
Certainly, I get to bat cleanup. You'll see that from some of the things that you're about to view next, that we continue to update the website to try and make it more responsive to people who are visiting us, to get them to the information that they're looking for as fast as possible. By way of update with regard to the post-evaluation that the commission requested, I did have a conversation with them today. They believe that they'll be able to start interviewing within the next couple of weeks on that. It would have been earlier, but the guy in charge suffered a collarbone break while skiing, so it had a little more delay than we wanted. And the last thing that I did want to say with regard to the Susan Shelley matter, which did just come in a couple days ago, you could probably infer from the high-quality representation you see from the Enforcement Division when they present cases to you, just the level of quality that they bring to this commission. But what you don't see is the 2 years that lead up to that 5-minute presentation that you get for these cases. And in this particular case, Commission Counsel Teresa Gilbertson did a phenomenal job. And it's, I'm hoping that once the commission starts hearing these matters for themselves, you'll be able to have a little more flavor for what a high quality of work that the Enforcement Division and the Legal Division put into their cases. So a shout out to Commission Counsel Gilbertson. And that's all I have unless there are questions.
Any questions for Executive Director Jones? Commissioner Wilson?
I just want to make a quick comment. I would definitely agree that, the quality of work, as the newest commissioner is very impressive in all the divisions, the senior managers, the staff, everyone's very responsive to questions. So I would just, reiterate what you just said. So thank you.
Thank you.
Good job. All right, Ms. Hahn, back up.
So my report that you receive is submitted, but I have other part of my report that I would like to do that it's not part of the written material that you receive. Let's do the ad watch. I'm sorry, not that watch, the PSA first. You have to share your screen. Okay. So what you're about to see is what Chair Matich has mentioned earlier. We work with our communication director, Jay, and IT and legal team to acquire a public service announcement that we will do starting next week. You'll be able to see some of the public service announcement beginning at social media. And this is the first phase of the PSA rollout that we're going to do. And we would like to continue rolling them out as the election goes. And then we're hoping to do a little bit more during the primary in 6 months. So I'll let the video do the talking.
Want to know who's behind these ads? We're the FPPC, and we can help you find out.
Sorry. And then there's a link from the PSA to a new page that you've developed on our website.
So we'll be working on a link with the PS on the bottom of the very end of the PSA to link to our website, which we put together. It's to give voter information or any interested party information that's like election-related question that they might have. So we broke it up to 4 sections. In the election basic, where do you vote? It's tied to another agency, which is the SOS website on basic election informations, campaign rules that they could find out, campaign advertisement, where they could find out the rules with campaign advertisement, our AdWatch link to our AdWatch if they have any maybe campaign that they want to submit for us to look at and they have question with. And then the third thing is how they track the money. So there's different web link that we provided so they could find out more information how to track the money. And the fourth, but not the least, is how you report a violation if you see one after reading all the material.
That's great. Thank you very much for doing that. I do just want to mention Jay Wairinga has spent, I think, a lot of time working on this, so I wanted to recognize his contributions. Thank you, Jay. Larissa, you and the IT staff have done a great job on this, I think, getting this done quickly and on a sort of a shoestring budget. And then Dave and Galena for helping with the content and design, and TJ for just making everything essentially run for us. So thank you, all of you guys. It was a good team effort. So, and as Larissa mentioned, this is really, this is the first time we've done something like this. This is for the primary. We hope to, with more time and more resources, do something more robust for the general election. And certainly we have time for that. So I don't know if commissioners have comments or questions.
No, I'm pleasantly surprised. I'm pleasantly surprised.
We like to hear that. Surprised. All right, so that's the PSA. Then you're also going to, I know a couple meetings ago, we authorized the creation of a enforcement transparency portal, and that's now up and running. It's live, and so you were going to give us a very quick update on that.
So a couple meetings ago, you have approved staff to go ahead and develop this search capability on the enforcement portal. So now it's live on our website. So if anyone, any curious mind want to know where a complaint's at, they could go with finding out by the name, using the names or that's involved in the case. It could be a complainant, a respondent, or a case number simply, and then find out the status of the case or the complaint that they have.
Great, and we're going to be continuing to refine this over the next few months, is my understanding.
As our chair say, this is a beta product, so we will refine it and fine tune it as we go down the path.
That's excellent. Again, thank you very much to your staff. We have a great IT staff, and these guys are working really hard on this for us.
Kind of a technical question.
Commissioner Wilson?
This is an excellent portal. Can't wait to do some searches on it. But prior to the rollout of this portal, how did the public get information on cases? Did they have to call up the FEPC or email? What was the process?
I would like Delaney to answer that question.
Here, I'll do it. I used to work in
I'm not trying to
enforcement.
put you
I
on
can
the
give the
spot.
answer.
I'm just curious. It's a general question. It's not,
sure, yeah,
It's not a trick question or anything. Just
Typically, they'd come in through the CPRA process, which is, in the past, it was a phone call. Usually now it's an email. So publicly, someone interested from the public could send an email and request documents related to a pending complaint or case. If they were press, they would go through the press office to get that information.
Okay. Okay, well, this is excellent work. Thank you.
Any other commissioner comments, questions? All right, thank you, Ms. Hahn, and again, thank you everyone that worked on both those projects for us. And then brings us to our final item, commissioner comments on proposed future agenda items. Any commissioners have comments they'd like to make?
Nope.
Commissioner Wilson, Commissioner Hatch? No, thank you. Commissioner Cardenas? All right, with that, do we have a motion to adjourn?
So moved.
Second? Second. Ms. Linker?
Commissioner Cardenas?
Aye.
Commissioner
Yes.
Hatch?
Aye.
Commissioner Wilson? Chair Matich?
Aye.
The motion passes.
All right, thank you, everyone.